Well, today's special presentation is brought to us by Jeff Rowley. He is our Director of Loss Prevention and Claims here at the Trust. And we appreciate Jeff taking the time to talk about this important subject of Utah's religious liberty protections. Jeff?
So the Utah Religious Liberty Protections Act is part of the Utah Anti-Discrimination Act that we want to talk about today, and it's a very short section, but what we have learned recently from the Utah Labor Commission and the UALV section of the Labor Commission is that most employers are really good on all of the federal statutes, but that this particular one seems to be one that people are unfamiliar with and that they get in the most trouble with, at least according to the Utah Labor Commission. And so we thought we would run through a short presentation and familiarize you with this, and hopefully then you can use this video to add this to your discussions of other federal protections that are part of what we must do as employers to guarantee the freedom of our employees, but to protect our business and our business interests in the workplace and manage our employees. And this all begins, of course, with the fact that we're Americans, and here it is just a few days after the 4th of July. We all have a renewed sense of appreciation for our country and for the rights that we all have guaranteed by the Constitution, including the freedom of speech, the freedom of religion, the freedom of press, of assembly, all of those freedoms which we enjoy. But of course, over time, it became very evident that though we support and promote these freedoms, that there needs to be some limitations in the workplace in order to allow us to continue our operations without disturbance or disruption. So let's see, why is it not advancing? There we go. All of these are based upon the theory that we need to have respect in the workplace for one another, regardless of our backgrounds. So the laws all begin with Title VII back in 1964, the Civil Rights Act of 1964, which says in part, it shall be an unlawful employment practice for an employer to discriminate against an individual with respect to his compensation, terms, conditions, or privileges of employment because of such individual's race, color, religion, sex, or national origin. Of course, we've all been trained on these things, and this begins to provide us with the concept of what's unlawful within the employment practice area. So what it is that employers can and cannot do within the employment area, including discrimination. And this statement introduces the protected classes: race, color, religion, sex, or national origin, which started it all off. And so what is discrimination under federal law? It is the unjust or prejudicial treatment of different categories of people or things, especially based upon a protected class. Well, that protected class group has grown in size with additional laws that have come. Some of these, just by their title, of course, are very familiar to us, and they're easy for us to identify: race and color. Some of them take a little bit more of an explanation or understanding to recognize what they are. And that they are a protected class. For instance, creed versus religion. Well, we all understand what religion is, and it's not necessarily an organization. It's your beliefs, your spiritual beliefs. But a creed is really just something you strongly believe in and ascribe to. For instance, I spent a lot of my life working with Boy Scouts, and I believe in the law and the oath of the Boy Scouts. That is part of what makes me me, and so that could be considered a creed for me. Gender and identity is sort of a newer one that's come on in the last couple of decades with regard to not only gender and gender changes, but how we identify ourselves within the context of gender, and how we need to be respectful of that and not discriminate or harass based on that. And genetics, you may be familiar with that, the laws behind that. All of that was an example of our federal government thinking ahead as to what might be coming when genetics become more popular or more capable in what they can do. For instance, it was thought that perhaps employers would say, well, we want to get a DNA sample from this person to find out if they are just predisposed to any kind of long-term and expensive diseases. And we don't think that should be allowed in the employment. And so laws were made to prevent that. So these are your protected classes in the employment arena, that you cannot discriminate or harass people based upon these categories. Now, what is harassment? Of course, it's aggressive pressure or intimidation, or further defined as the act of systematic or continued unwanted and annoying action of one party or group, including threats and or demands. Harassment and discrimination based on these protected classes are prohibited in the workplace. And again, we've all been trained on these kinds of things. But let's dive a little bit further into that. Harassment is any behavior or conduct based on a protected class, which is pervasive, unwelcome, insulting, demeaning, threatening, ridiculing, derisive, or coercive, and results in a hostile, abusive, or intimidating workforce and work environment. So discrimination and harassment comes since 1963, but since then we've had these additional laws that have created new classes and protections for us. These are all on the federal side. The GINA one at the bottom, that's your Genetic Information and Non-Discrimination Act that we spoke about. We should all be familiar with, of course, the Age Discrimination Act. I remember when I turned 40 and thinking, well, hey, I'm finally in a protected class, but that's been so long ago, the euphoria has long worn off on me. So there are lots of laws out there that we train on. Most of them have the same thing of just protecting an employee's rights and keeping them free of unjust treatment in the workplace. But Utah has taken it a bit further with the Anti-Discrimination Act, which is administered over, as I mentioned earlier, by the Labor Commission and the Utah Anti-Discrimination and Labor Division. And they've been very helpful as we've talked about this, and would really like to see more employers understand this Utah Religious Liberty Protections Act and what it means. So let's talk about that for the next few minutes. The act itself really only has two sections. The first section talks about what is protected, and then the second, where it's protected. So here's the first section in its entirety, and I'll flip it over to this one with the red line version so it's easy to pull out what's important. An employee may express the employee's religious or moral beliefs and commitments in the workplace in a reasonable, non-disruptive, and non-harassing way on equal terms with similar types of expressions of belief or commitments allowed by the employer in the workplace, unless the expression is in direct conflict with the essential business-related interests of the employer. And so what's protected? Religious or moral beliefs and commitments, and the expressions of those in the workplace. So they are topics of conversation that are open to be discussed in the workplace, and the employer can't discriminate against them or take any actions for them, so long as they're reasonable and non-disruptive. For instance, if somebody comes in and expresses their strong belief that USU has better ice cream than BYU, well, you know, you can talk about that all day long, and it can get rough, and people can.
It's a statement of fact. Yeah, that's a statement of fact.
Well, it certainly is for anybody north of Ogden, it seems, but there are some others that think otherwise. And those are probably some pretty strong beliefs, but they aren't necessarily religious or moral beliefs. And I've not yet met anybody who is so committed to USU's ice creams that they would consider that to be sort of a creed of theirs in their life. But there are other things that you can think of that clearly would be. Right now, we have a hot topic of conversation around abortion because of the change from the U.S. Supreme Court, police civil rights issues, all kinds of things that people have very strong opinions on, including politics. And those, so long as they are allowed by the employer, meaning that they are not in direct conflict with the nature of the business of government. Now, I can't think of too many items, topics that would be in direct conflict with the government unless they're something that in and of themselves discriminates or disparages a particular part of the population. But you can think about other employers, some who might be in the meatpacking industry. If someone comes in and wants to express their strongly held belief that we shouldn't be eating meat or we shouldn't use leather or whatever, that obviously is in direct conflict with the nature of the employer and an essential business interest. And so the employer can regulate that discussion point and say, you need to talk about that away from work. But other than that, any strongly held moral belief or commitment or religious belief should be allowed in conversation within the workplace without any sort of employment reprisal. Now, the second part of the Act says an employer may not discharge, demote, terminate, or refuse to hire any person or retaliate against, harass, or discriminate in matters of compensation or in terms, privileges, and conditions of employment against any person otherwise qualified for lawful expression or expressive activity outside of the workplace regarding the person's religious, political, or personal convictions, including convictions about marriage, family, or sexuality, unless the expression or expressive activity is in direct conflict with the essential business-related interests of the employer. Highlighting the essential points there, an employer cannot take essentially any employment action based upon the free speech expressions of people outside of the workplace for those that are otherwise qualified for their position, which I think that may have been a little inartfully crafted. I'm not sure why we put that in there. If somebody's not qualified for their position, that's a good reason to take action against them, including not hiring them. But whether they're expressing their opinions outside of the workplace or not really doesn't matter. But you can't, and this goes back to their free speech on generally their social media posts and outlets, as well as in the streets. And if they end up in the news media, your employees out there, they're expressing their interest in being pro-animals, pro-life, pro-whatever it is. They have the right to do that, and you cannot take employment action against them unless that expression, again, is specifically in direct conflict with the essential business purposes for your organization. As a government, again, you'd have to think carefully and discuss this with your attorneys on what that really means within the confines of your work environment. So in a nutshell, people can share their beliefs in the workplace and outside of the workplace, and that cannot be a reason to discipline an employee or take any sort of action on their employment within the workplace. Now, this does not say that an employer can't ask that an employee not post there that they work for you at the same time that they're expressing their beliefs. You can ask them not to do that. This doesn't preclude that, so that it takes away perhaps that link or connection to your workplace. But this is kind of a tricky thing. We as public entities are always interested in making sure that we put our best foot forward in serving the public and the entire public. But when you have employees out there that are known employees of yours and they're expressing their strongly held beliefs, that is outside of employment and against Utah law for us to then take action against them because of what they put up in their private endeavors, including their social media pages. So interesting scenario that this can create. And again, according to the Utah Labor Commission, this seems to be the issue that employers in Utah are cited on when it comes to some kind of harassment or discrimination against a protected class. So it's right to be aware of this, and you'll want to maybe think about very carefully with your legal counsel how to handle a situation where an employee is expressing themselves and the public is coming back and saying, look, you hire these kinds of people that believe this way, or I know this is your employee and this is what they have posted on their website. Is that right for a city to do that? Well, it's not the city doing that. It's an individual, and that's their protected right, and it's against the law for us as employers to take any kind of action based upon their religious or strongly held beliefs. So that's the act, but on top of that, this act also prohibits any kind of retaliation for anybody that participates in an investigation, that reports it happening, or reports any sort of inappropriate action taken by the employer to the Utah Labor Commission or others. So again, as with the other protected classes and protected behaviors, retaliation is against the law for violating the Utah Religious Liberty Protections Act. So that's the presentation and the law. Thankfully, there's only 2 sections, but apparently we're getting hung up on that. So I'm happy to take any questions now if any have come in.
So folks, if you have questions, please type those into the chat box, and we'll get Jeff to answer those right now. Kind of a real tightrope in a couple of different angles, right, Jeff? I look at this and I think as an employee, I have these freedoms to express my own personal beliefs, but that's kind of a tightrope as well, and what I share in the workplace and those things. But as an employer, we also have to know, and that's really what we're talking about today. But it's a tightrope to balance those things.
And that's why it comes back to respect in the workplace, respect for everybody and their rights, just like yours. You want to protect yours. You know, if you have a conversation about something that's a strongly held belief and it starts to get hot, you know, it's time to back off and just respect that other people have different opinions, and you can carry that conversation on elsewhere. But within the workplace, it must always remain respectful, and that not only is for the person who begins by expressing their strongly held belief, but it often can become a problem for people who then come back and express their opposing opinions. And those conversations are what we need more of in this country, so that we can help to understand each other, but in a respectful way. And then to recognize that you know, people have the right to express whatever they want on their own time outside of the employment, without any kind of fear of reprisal from their employer.
That's great, Jeff. Yeah, I have the right to express myself, but I also have the right to keep my opinions to myself. So
Absolutely. Right.
That's generally where I choose to stand on many items. So well, I'm just looking here and I don't see any questions in the chat room or comments. So unless they come in right now, I think we've about finished the day. Final words, Jeff?
Well, we've got the reference to the Anti-Discrimination Act, as well as directly to the Utah Religious Liberty Protections. The rest of the act is very small, really just proclaims that we're not taking away any rights that are guaranteed under the federal Constitution. So these 2 sections are really the meat of it and easy to digest. So if you have questions, you can let us know, and certainly talk about these things with your counsel if an issue comes up, and tread carefully, because in these situations you're dealing with people's rights granted by the United States and by the state of Utah. Thanks everybody for your time.
All right, Jeff, thank you. We did have a couple of questions pop up just after that, so
okay.
You almost got away with it. It says, let's see, Larry says, I presume as long as the employee doesn't identify themselves with the employer, correct? So
well, so the employer, the act doesn't say that the employer can't ask them to remove the reference to them as their employer from their website. It doesn't say that you can anything about that. So it may be on certain ground to demand that you do that, or that there be some reprisal in the workplace. I don't know that I'd go that far, but it doesn't say you can't ask them to disassociate themselves from you as the employer.
So if you if an employee would represent themselves as I'm representing my employer, I'm representing this organization, and this is my belief, that could be going across the line because they're saying something that's not necessarily the position of the employer.
Absolutely, absolutely. If you don't have the right to represent your organization, then you should not be representing that is the opinion directive of your employer. I experienced a situation earlier in my career where an employee did just that and put their opinion on the Salt Lake County District Attorney's letterhead and sent it out to the media without permission from the DA, and there were some strong reprisals for that.
How about prayers in the workplace?
That's a good question. Prayer is a religious belief and an expression of your religion. There is nothing, as far as I know, that says you cannot pray in the workplace. I'm personally grateful for that. If you have a situation where it becomes disruptive in the workplace, then I think the Act, says that you can take some measures there, but you want to look at that very carefully because freedom of religion is a strongly held protection.
There's also the opposite side of that as well, as if somebody is praying, requiring somebody who doesn't share those same beliefs would be on the opposite side of that, protecting that person's belief as well. So your personal expression would probably be fine. Let's see. James says, what are your thoughts on display of flags, political or otherwise, or religious symbols at the workplace?
The Act, I don't believe there's been any case law defining that further in the state of Utah that has come out. But if, again, the Act says if the employer allows other expressions of that nature in the workplace, then your strongly held belief should be something that you can display, so long as it doesn't go against the core functions of your business or ideals of your business.
Or harass or discriminate others in the workplace.
That's right.
So
that's right.
So if I could just, I get the luxury of reading that a few seconds ahead of Jeff, so he doesn't have the time. But just thinking of examples there, I would be careful about that, about those types of expressions. Just because something that you find, hey, this is my political candidate or my party or whatever, it's what I believe in. That's great. You may have right to do that, but you also need to think about the other side of that coin. There may be somebody with a belief that you really don't like. Somebody comes in and puts up, let's say, a Nazi flag in the workplace. Could that take us another route and maybe seem to be discriminatory to other people? So I think it's that balance, right? Would you agree with that, Jeff?
I agree with that completely, and those are cases where open discussion can be had, but certainly sometimes you just have to set down the rule that this is discriminatory against this group, and we don't practice that in our workplace.